Hi, Boonies. Sarah's Wednesday, August the 14th court hearing is here. And today I want to look at the couple of documents that have dropped on the docket since we last visited the docket. There's been a motion filed by WFTV Channel 9. It says WFTV Channel 9 moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings in support thereof. The WFTV states as follows. WFTV has covered the murder of Jorge Torrez and the arrest, investigation, and prosecution of defendant Sarah Boone. Reporters from FWTV attend court hearings and rely upon state, county, and local public records, as well as judicial records, as their part of news gathering process. This court has set a physical viewing of the evidence for September the 3rd and is set to consider the media's attendance at the viewing during a hearing on August the 14th. Any closure of the physical viewing directly affects the media's and the public's right to monitor this important criminal proceeding. As such, WFTV has standing to intervene and oppose any requested closure. See, I disagree. Now, they're referencing this Miami Herald thing, and we're going to look at that too. WFTV would like to be heard in this matter and asserts that any request closure should be denied. Florida has traditionally served as a model for open government and courts. It is well settled in the state that criminal court proceedings are presumptively open to the public. The Florida Supreme Court has stated that a trial is a public event and what transpires in the courtroom is public property. Therefore, when considering a request to close court proceedings, this court should begin its consideration with the assumption that a pretrial hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. In order to justify closure, the moving party must meet an exacting standard and show closure is necessary to prevent a serious and imminent threat to the administration of justice. No alternative other than a change of venue would protect the defendant's right to a fair trial, and closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. They keep going. 7, 8. Do you guys want me to read all of this? First, closure is not necessary to prevent a serious and imminent threat to the administration of justice. The fact that the proceeding will involve viewing evidence does not alter this court. More case examples. And they say, and any attendant publicity is not synonymous with prejudice, as the Supreme Court explained. Prominence does not necessarily produce prejudice, and juror impartiality, we have reiterated, does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merit of the case. Every case of the public interest is almost, as a matter of necessity, brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not had some impression or some opinion in respect to its merits. A presumption of prejudice, our decision indicates, attends only the extreme case. What do you guys think about that? Because I'm like, I do feel like before cameras could go in the courtrooms like this, everybody got a more fair trial. Did y'all see the Netflix thing on Trial by Media, I think was the name of it? And who says somebody's not going to lie just because they want to get on the jury because they want to say that she's guilty? How many of you out there would do that? Come on, don't lie. Be real. Would you lie to get on the jury just so you could vote her guilty? All right, I'm not going to read all this. Basically, it's just stating that she could still have a fair trial. And the funny thing is they're putting all this out there, and they know that Sarah can't come back with anything legal. It's going to change the judge's mind. Now, there was one other thing. So it's 151 pages. That was that's the packet from the JAC. I was going to go over that with you guys on a different. I guess we couldn't go over it. I get what the news station is saying, okay? But, and I'm all for media being out there because the more they show, we can watch it together, right? But you guys, we don't want this woman to have anything for appeal. There's some really good appellate lawyers out there who are going to come in here, and there's some probably already, their mouths are watering over this case to jump in and take it over once the trial finishes. I don't want us to get caught up in that. I really like this judge. I think he's very intelligent, and I think that he knows what he's doing. And I'm just going to have faith in that. And we're going to pray that he does the right thing here. The fact that he put out that Miami Herald previous action, what was it called? I forget, you guys. I'm sorry, I'm not an attorney. He put that out there on the docket, or he gave Sarah a copy of it. It makes me worry that he's going to come in and say that he's going to allow cameras. Okay, so this was the 151-page Justice Administration Commission's pro se packet. And it was a copy of the foregoing has been sent by U.S. mail to Sarah. Now, this was done on 8/9. I'm assuming she would have it by now. More than likely, the judge is going to go over this. Oh, she must have already written them a letter. Thank you for contacting the JAC regarding your public records request. In response to the court's request received by JAC on August 5th, enclosed, please find a copy of the JAC policies and procedures for pro se individuals, as well as JAC's invoices and other related pro se forms, which may assist you with your request. The due process rate charge and a complete list of service providers that have executed contracts for payment by the JAC in the Ninth Circuit Judicial Circuit are also provided. Blech. That's too many C's for me to spit out. Please be advised that the JAC pays only those due process costs which have been authorized by an appropriate court order. You will need to file a motion with the court requesting the court's approval for payment of any due process services. JAC will need to receive a copy of your motion at least 10 days prior to a court hearing on the motion. If your request is granted by the court, JAC will need a copy of the court's order in addition to a completed JAC invoice to process the payment. The JAC invoice must be signed by you and the due process vendor and must be signed after the work has been completed. Oh, y'all know she's all up in arms about this. She's like, oh my God, this is too much. What? I don't understand. Why are you punishing me? Why are you punishing me? Oh, and then they're like, oh, if you should have further questions, please visit our website. She's going to bring that up tomorrow. She's going to say, well, they want me to go to their website and I can't access the internet. I do not have Wi-Fi, Your Honor. This goes into, I'm going to kind of skim over this really quickly. Okay, so it's like they're going over the requirements of being an indigent, establishing indigency, allowable cost. So what are the allowable costs? Let's go through them real quick. Court reporting and transcript cost, interpreters and translators at depositions or witness interviews, which they may need translators in this case, you guys. Private service of process when the sheriff is not available or unable to provide service. Private investigator services, including costs to obtain case-related material or documents. Mitigation specialist services in capital death cases. What is a mitigation specialist? A mitigation specialist will tell the defendant's story to the jury in order to advocate for his life. Mitigation specialists also provide expert insight into criminal culpability, helping courts to understand a defendant's mental health or developmental disorders. It's plural. Back to our document. Expert witness fees. Mental health professionals. See, I was going to say mitigation specialist would be part of an expert witness, but it's not. Okay. Reasonable pretrial consultation fees and cost and travel costs for witnesses and obviously investigators. Now they've got established rates. Here's what they will not process. Okay, they cannot process. They have no authority to process bills for legal materials, office supplies, access to legal research materials, postage, or telephone charges. Oh, because I mentioned this earlier and I thought, did they give her a telephone card? They won't. A defendant is not entitled to additional costs because the defendant is in jail. Interesting. I did not know this. Such supplies are provided at the institution in which the defendant is incarcerated. If being in jail makes self-representation difficult, a defendant may wish to request that the court appoint an attorney. She's already tried that. Please know that pro se Defendants cannot be paid for representing themselves. Darrell Brooks. JAC generally does not process bills for costs in civil cases. Okay, well, that doesn't apply here. Unless otherwise indicated, JAC is basically kind of what we just read. There has to be a motion and court order for them to pay for anything. Makes a lot of sense. Their response time is typically within 5 business days. And that's going to drive her insane. I think she has their phone number too. Now we're getting into the definition, I guess, or exactly what in regards to transcripts, script copies, expedited rates for transcripts, videotape depositions, all of that. They're kind of going into how that works. Then they talk about the investigator. Now let's go over this because we know Sarah and we know what Sarah's going to want her investigator to do. So let's see exactly what the JAC is going to pay for him to do. His role. The role of a private investigator is limited to providing investigative services such as locating and interviewing witnesses, locating and securing documents and other evidence related to the case, performing background checks, and researching any factual issue relevant to the case, such as credibility and character of a witness. An investigator is not a substitute for a paralegal or secretary and cannot be used to perform administrative tasks. Boom! I'm so glad that I opened this document because you guys know this is going to come up. With prior court approval, JAC may pay process bills for costs to obtain documents such as charges for discovery related costs or for medical records of the defendant. These costs are usually paid for by the investigator and then reimbursed by JAC. JAC can only process bills for mitigation specialists in capital cases, in which the state is seeking the death penalty. Okay, well, she's not up for the death penalty. So that's out. We don't even need to look at that. We know they'll do expert witnesses. But, one of my questions here is like, what if one of these expert witnesses that's already done their thing on this case has already been paid or started to be paid? Like, let's say they've done a little bit of work, they've been paid thus far, they're going to get paid again when they come to court or whatever. My question is if Sarah tries to change the experts up because she doesn't like what they're saying, because we know how she is the JAC going to be like, no, you can't do that. We've already started with this person, or we've already approved this person. The defendant has the burden to show the particularized need for the expert services. The information in the motion should be sufficiently detailed for the trial court and the JAC to understand the need for the requested expert. Now, experts include psychologists, medical doctors, crime scene experts, accidental reconstructionists, DNA experts, ballistics, firearms experts, and other persons with specialized knowledge and training that permits them to testify as an expert before a court. And as Barbara likes to say, are we going to have somebody come in from the Samsonite manufacturing company and give us a thing on their zippers, on their suitcases? Obviously there's set rates, and they'd already talked. We went through this when she had Bankowitz because he was having a hard time finding somebody that would work with Sarah, number one, and number two, agree with the rates that JAC pays. Obviously, they don't pay a lot, which is kind of scary. That means that they aren't going to hire the best, She can't bring anybody in from out of state. It's not authorized. It says the JAC does not verify the professional qualifications of the persons listed. It is the sole responsibility of the party using the services of a person listed to verify their professional qualifications. Experts are generally paid on an hourly basis. Generally, the defendant is only entitled to one expert in an area, such as mental health. If the defendant desires more than one expert in similar categories, the defendant must establish the reason for the appointment of multiple experts in the same general area. And we know that Sarah will argue her case exhaustively. Oh, speaking of exhaustion of amount of authorized. When using a due process vendor, the defendant should inform the due process vendor of the amount authorized by the trial court. If the vendor is going to exceed the amount authorized, the vendor must immediately notify the defendant if additional services are required so that the defendant can file a motion with the court for approval of state payment of additional due process services. The defendant should file a motion requesting additional services before the due process vendor performs any additional services in the matter. So this is where they could come back and say, okay, you started with this one. We've already paid this much towards this mental health expert. And now you want to bring in another mental health expert. There's not enough money there. You need to ask for additional money. I don't see how that's going to be allowed, especially when we know the reasons that Sarah throws them out. Now they talk about their invoices, submitting bills and stuff. And I know there's copies of their invoices in here. They have a vendors list in here. Here's a copy of their motion. She'll use this. She'll be able to handwrite over that. She makes copies. Is there a copy machine at the jail that she's allowed to use, I wonder, for this kind of stuff? I mean, they'll probably charge her for it, but these are just different forms for different reasons that they're going to need. And then we get down to, it's just basically an example of each form. And then we'll get down to the invoices, what the invoices look like that they have to fill out to then send to them. There's one of them. Dang, this is like filling out your income tax. Look at this. Oh, instructions. Well, at least they give instructions. I think that's all there is, y'all. Let me go faster. There's nothing else. Oh, they got their due process vendors list. Yeah, this is just their vendors list for the different things, which is going to be very helpful for her because she's not going to be able to reach out to different people. So having somebody already that she's got a contact information for will be good for her. At the end of the document, these are the court minutes that we've already gone over. Okay. But then this is the Miami Herald Publishing Company versus Royce R. Lewis. Media appealed from ruling entered in the Circuit Court, Indian River County, Royce R. Lewis J., which closed pretrial hearing on the motion to suppress confessions of alleged murder and sealed records pertaining to that suppression hearing until selection and swearing in of a jury at forthcoming trial. The District Court of Appeal affirmed in part, reversed in part, and remanded with the directions and certified the matter as one of great public importance. The Supreme Court, Adkins J., held that there is no First Amendment protection of the public's and press's rights to attend pretrial suppression hearing as distinguished from right to attend criminal trial, and summarized guidelines for trial judge to use in applying the three-pronged standard. So they're saying that there's no difference in a regular trial versus what you're going to be doing here at this hearing. How can the trial courts meaningfully include the media at evidentiary hearings convened to decide whether the media should be precluded from access to that very same evidence? Should this court abandon the three-pronged standard which we adopted in Miami Herald versus State in view of the holding of Gannett? The district court held that in light of pretrial publicity, the trial judge in the murder trial of Brooks John Belay properly ordered closure of a hearing and on a motion to suppress Belay's confessions, but that the judge improperly sealed records pertaining to the suppression hearing. So I guess he feels like they could literally cause problems in the court for a retrial or something like that. The facts upon which the trial judge based his order closing the hearing and sealing the record are as follows. 14-year-old Brooks John Belay became the focal point of an investigation into the murder of 4-year-old Angel Halstead. Angel's disappearance, the search for and discovery of her body, and the investigation into her murder were all extensively covered by local news media. Belay was interviewed and quoted widely by the print and broadcast media, perhaps because of his active role in the search and his seemingly intimate knowledge of the crime. Belay was questioned by police shortly after Angel's body was found. He gave them 4 inculpatory statements. The details of the search, the killing, and Belay's confession were widely reported by the press as were certain of Belay's pretrial hearings. Dozens of articles and several videotapes of television broadcasts were presented by Belay's attorney to the trial judge. The tapes and articles made numerous and repeated references to Belay and included interviews with him and quotations from him. The public had been made aware by the news media that Belay had confessed to the crime. The public was virtually inundated with information detailing the crime. Petitioner's position in the matter is that the court should formally adopt the so-called three-pronged test for closure of judicial proceedings, and that press participation in closure motions poses no threat to the fair administration of justice. The three-pronged test, finally, let's get to what it is, would impose the following requirements of an order to close a pretrial hearing. 1. Closure is necessary to prevent a serious and imminent threat to the administration of justice, which to me is vague. 2. No less restrictive alternative measures than closure are available. And 3. Closure will in fact achieve the court's purpose. Then they just go on to talk about how this works. I feel like he's going to go forward with it. I feel like he's going to let him in the courtroom. They do bring up analysis, balancing rights today, social media versus press and television. I want to read this. This is a lot. If you guys want to read it, I guess I could put it up. I could attach it maybe. I think I can attach it. My technology challenge self will figure that out. The media intervener's motions in the trial court required a balance of the defendant's due process right to a fair trial in Miami-Dade County, where the charged offenses alleged were committed, and the rights of the public and media to access records under Chapter 19, and to observing court proceedings under Richmond Paper Inc. versus Virginia. There's a bunch of state cases referenced. These competing rights were addressed by the Supreme Court of Florida in Miami Herald Publishing Company versus Lewis, adopted a three-pronged test in assessing such cases, and it carefully differentiated between pretrial proceedings and criminal cases and the actual trials of such cases. Importantly, the present case involves demands for information revealing the substance of a confession. That's different than what we're talking about here, but it's still evidence. And for the other pretrial discovery materials, the orders below and the petition here do not require us to address the higher constitutional rights of access to the courtroom and case-related records applicable to a trial. I don't have the gasoline right now, you guys, to go through this and read all this to y'all. I'm sorry. Y'all don't come here for the legal advice anyway. So I want to take a minute to say, what could we possibly see? The suitcase. They're going to show her the suitcase. She's going to want to mess with that suitcase. I bet she's dying to get her hands on it to see how the zipper does. Or have somebody do it. There's going to be the empty wine bottles and the receipts. There's going to be a lot of I think most of it's digital evidence. You can't bring the apartment complex, or you can't bring the apartment to the courtroom. So we're going to have to rely on photos of the apartment. There's going to be a lot of photos of the crime scene. I don't see how it could really be that big of a deal. I think he's going to allow it. And just a reminder, you guys, I know this hearing is at noon tomorrow, but what we're going to be doing is waiting until 6 o'clock to watch it together, okay? So if you can hold out till 6 p.m., join us on a live stream. That way we can all chat about it as it's happening. I would appreciate you doing that. And I've been putting out a lot of videos lately, and I heard through the grapevine one time that you only get like so many notifications a day. And I don't know if that's true or not. We all know that people complain about notifications. But if you think about it, as much stuff that goes out and as many channels as you could be subscribed to, there's no possible way for them to give you a notification on every single one. You'd be inundated. So I'm not really sure how that works with YouTube. So what I would suggest, if you want to continue to follow us on this trial, is to just keep checking back on my channel and see what we're uploading on a regular basis. I'm uploading in the morning, afternoon, and the evenings, trying to get as much out there as I can before the trial starts. So just keep checking back on our channel main page every day, if you don't mind. I really appreciate that. I'm not going to let anything get past us. If something comes out there, I might not be the first one out there to put it out on, on YouTube, but I will address it and we will go over it. Okay. Thanks for being with me, guys. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.